Yes, my lord. You'll see that we have there the Public Records Act. We're sending you an electronic copy as we speak, which should be with you, I hope, shortly. So we were in the process of construing, in particular, Section 3.1. We need to do that in context, and I'd asked the court to look at Sections 3.1, Section 3.2, and Section 3.4. In particular, Section 3.4, which provides that public records for permanent preservation under this section shall be transferred not later than 20 years. That's the point that my lord, the Master of the Rolls, was making. The 30-year period has now been brought down to 20. After their creation, either as a Public Records Office or such other place of deposit appointed by the Secretary of State. Now, other than those sections, if I can ask the court to turn to Section 10. In this Act, public records has the meaning assigned to it by the first schedule of this Act, and records includes not only written records, but records conveying information by any other means whatsoever. So that will obviously include records conveying information by WhatsApp and so forth. And then Schedule 1, Para 1, and Para 2, subparagraph 1. Can read those. And then, as for methods of construction, we have included in our authorities bundle at tab 46, in the authorities bundle at tab rather 48, Benyon, and an extract from Benyon dealing with the principle of effectiveness. That's page 1698. An enactment must be construed so as to implement rather than defeat the legislative purpose. And if the court can read the comment in the first quote. So, context here includes the provisions of Section 3.4, which give a department of government or the person responsible for preparing documents for permanent preservation up to 2 years, 20 years to do so. So we submit that in construing Section 3.1 and the need to go back to that wording, shall be the duty of every person responsible for public records of any description which are not in the public office or place of deposit appointed by the Secretary of State under this Act to make arrangements for the selection of those records which ought to be permanently preserved and for their safekeeping. And our simple point is that as a matter of necessary implication, this provision requires arrangements to be made for the storing and preservation of records or documents or information until such point as the selection is made from amongst those preserved records for their permanent preservation. Because unless that is the case, and there is no duty to make such arrangements, then it necessarily follows that the entire purpose of the legislation will be defeated, because there will be nothing to stop individuals from deliberately or simply because no such arrangements exist, from destroying records which are of a nature and purpose that should be permanently preserved. So it must encompass the duty to make arrangements, those arrangements which are anterior to any arrangements for the actual selection of documents for permanent preservation. And the respondent says that the implications of this are that every record would be required to be retained for 20 years. And of course that's nonsense with respect. the arrangements are such that when it comes to the time to make the selection for permanent preservation, the relevant corpus of documents need to be preserved from which such a selection can be made. And there are numerous ways in which you can do that. You can make a provision that says, well, right from the beginning, and on a regular basis, you are to root out ephemeral and other records and communications that are of obviously no significance and will not require permanent preservation. And in fact, we can see that's exactly what these policies do. They distinguish between classes that might require permanent preservation or documents that are required for other purposes, such as Freedom of Information Act requests, from those that are quite obviously not going to require permanent preservation. And that is something, that is a sifting that happens in the early stages. It's also quite possible that you could set up a system which brought forward to well before 20 years the date upon which you are going to make the selection for permanent preservation. The point is, all that follows from by necessary implication is that you have to have arrangements that will ensure that you do not destroy, before the point at which you make the permanent selection, documents that will ultimately be or fall within the class of those from which would meet the permanent selection criteria. And there are manifold ways in which you can do that. And in fact, that is exactly what all these policies aim to achieve and do achieve. So that's our simple submission. One cannot construe this legislation without that necessary implication being read into it, and in order to give effect to its statutory purpose. And one answer that the Divisional Court gave was that the frustration principle is a way in which you can construe it, absent that necessarily implication, in a way that ensures that its purpose is given effect to. But in our submission, the frustration principle simply does not do the work necessary. The frustration principle addresses only a policy or an arrangement that is actually designed to frustrate or thwart the purpose of the legislation. But what is required here, by necessary implication, is a preservation policy pending selection that positively supports the process of selection. That's an important distinction. There is another way to look at this, and even if the court were to conclude that such a power is not necessarily implied, or such a duty to make arrangements rather is not necessarily implied into section 3.1, what is unquestionably the case is that the arrangements themselves and the exercise of the power in making those arrangements is incidental to or ancillary to the section 3.1 power. It facilitates it, and it facilitates effect being given to that power. So, can I turn then to the legal status of the Cabinet Office Security of Government Business Policy? As I said, that is not a PRA arrangement, and its status, its origin, its source is not positively identified by the respondent. And there are two possibilities. It's either an exercise of the prerogative, or it's what I described earlier as a third source power. Effectively, its authority or the power is a common law power which exists in respect of any individual to exercise those powers that an individual possesses to conduct their business. And there are authorities which address third source powers, their nature and the way in which they are governed by public law. But before I address those, can I just simply retrace where I went this morning about the nature of that policy, which is, as we have submitted, mandatory, unambiguous, unequivocal, in the terms which we have seen quoted with respect to the use of private devices and communications systems. Can I ask the court to look at the case of Shrewsbury and Action Borough Council, which addresses, Court of Appeal case, which addresses third source powers. It's at tab 16. Page 389. I'm just going to read a couple of small paragraphs from the headnotes so the court has a sense of what the case was about. It's a decision of the Court of Appeal with Lord Justices Waller, Carnworth and Richards, as they then were. The defendant, at the beginning of the headnote, Secretary of State, published a white paper and brought forward proposals by which two-tier local government in some parts of the country would be replaced with unitary authorities. And then heading down to G, on the right-hand side of the page, just above G, a policy decision had been made not to use the existing legislative machinery under the Local Government Act 1992, but instead to promote new legislation. The Local Government and Public Involvement in Health Bill was introduced to Parliament with a view to conferring the necessary powers to implement the proposals. The authorities brought judicial review proceedings, that's the local authorities, brought judicial review proceedings to challenge the process adopted by the Secretary of State and the decisions made in the course of the process. They argued that she had no right to embark upon the exercise before the enactment of the necessary legislation. And if the court then turns to paragraph 43, which is on page 402, and the heading is Powers, Common Law or Statute. The other two issues require more detailed treatment for reasons which will become apparent. It may be artificial to separate them. Virus. The existence of a residual category of ministerial power, not dependent on either statute or prerogative, is a matter of continuing academic controversy. One aspect is the so-called RAM doctrine, which has been interpreted as enabling ministers as representatives of the Crown to do anything that a natural person may do except if prohibited by statute. However, for present purposes, as the judge held, the answer seems to me to be dictated by the decision in ex parte C in the judgment of Lady Justice Hale at 21. That decision, which is binding also on us, confirms that the powers of the Secretary of State are not confined to those conferred by statute or prerogative, but extend, subject to any relevant statutory or public law constraints, and to the competing rights of other parties, to anything which could be done by a natural person. The court then turns to paragraph 48, page 404 at the bottom. Reference to the status of a minister of the corporation sole or to analogies with the powers of natural persons seem to me unhelpful. In the case of an artificial person, it may be important to distinguish between the power to act as a matter of corporate capacity and the legal constraints limiting the exercise of the power. Unlike a local authority, the Crown is not a creature of statute. As a matter of capacity, no doubt, it has power to do whatever a private person can do, but as an organ of government, it can only exercise those powers for the public benefit and for identifiably governmental purposes within limits set by the law. And if we then turn to Lord Justice Richards' judgment at paragraph 73 to 74, and that's at page 411. Can I ask the court to read paragraphs 73 and 74? point of distinction between them is as to whether or not the exercise of governmental power is always limited to that which is for the public benefit. But where they're both agreed is that the exercise of such powers is subject to judicial review on ordinary public law grounds, and that's precisely the same in relation to the prerogative as was established in CCSU. So, just for your Lordship's pen, then there is the judgment of Lord Justice Waller at 79 to 81, where he doesn't resolve that issue, and he instinctively favours some constraint on powers by reference to the duty to act only for the public benefit, but notes that that doesn't need to be resolved. So that's what we take from that authority. Third source powers exist. Some are undoubtedly exercised for the benefit of the public, and they are subject to ordinary principles of judicial review. For completeness, could we turn to tab 22 and to the judgment of the Supreme Court in New College, London, and the Secretary of State for the Home Department. And if we can go straight to paragraph...
Page?
Sorry, that's page... the judgment starts at page 717, and if we could move into the judgment of Lord Sumption and paragraph 23. Could I ask the court to read 23, to the last three lines, and don't include the last three lines, but all of that are the last three lines. And from there to 26, there's an analysis of the legislation, and he concludes, for those reasons, I accept Mr. Drabble's starting point that the criteria for sponsor licensing contained in the guidance did not fall within sections 1, 4 or 3.2, and did not fall, therefore, to be laid before Parliament. This disposes of the claimant's argument. I turn, therefore, to Mr. Drabble's principal submission, namely that on the footing that the criteria for sponsor licensing did not fall within those sections, there is no power to have a system at all. And if one then moves to 28, and the sidelining of 28, if the court could please read that. So again, matters that are unresolved, but no question but that there are these third source powers. As to their precise nature and scope, that remains unclear. Finally on this, if I can ask the court to look at some academic literature of Paul Craig, which is at tab 49.
So just pause there for a second. Am I right in thinking this is opposite then, because Lord Sumption appears to say at the end, this question doesn't need to be resolved in these appeals, because the statutory power of the Secretary of State to administer the system must necessarily extend to a range of ancillary and incidental administrative powers not expressly spelled out in the Act.
Yes, so those are ancillary powers, but the existence of those powers is already established by...
Yeah, but my only point is I'm not sure this really helps you.
No, I just wanted to put that there for completeness, just to make it clear that this has been considered and looked at also in the Supreme Court. So there are either ancillary powers and third source powers. And plainly, the SGB is not an ancillary power because it's not ancillary to any statutory power. But the other policies are either Section 3.1 powers, ancillary powers, or third source powers. And then finally, Craig, that's tab 49, and the relevant paragraphs are 1906, where the relevant case law is reviewed, and then 19007 is where he sets out a trend of the case law. And perhaps just for the court's note, if the court could read 19007.
Sorry, do you mind just giving the page number?
Yes, it's 1702.
Thank you.
Can I then come on to the question of the justiciability of the ministerial code, or the SGB, because the SGB and the ministerial code are linked in the way Ms. Harrison described? And
Why do you, sorry, before you leave third source powers, why do you say it's not an exercise of the prerogative?
Because it doesn't seem to be a power that is a recognisable
Security?
residual.
Security is, I mean, the security of the state was one of the first prerogative powers, and this is a security of government business. So why, I can understand there may be arguments against it, but I'm pretty surprised there's no argument that this is in the prerogative.
I'm happy to accept that it's.
Well, I'm not saying it is. I'm not making the arguments.
I'm not challenging whether or not the power exists. I'm happy to accept it's a prerogative power, or it's a third source power. Whatever the source or the nature of the power, it is subject to judicial review, howsoever it is characterised. That's the important point.
Well, the exercise of the power is.
Yes.
But what you're seeking to judicially review may be different, because you're saying actions carried out under the policy are the target of the judicial review, not the decision to make the policy.
No. So what I'm talking about is the enforceability of the policy. That's the challenge. The actions, insofar as they fail to comply with the policy, are only unlawful if the policy itself is enforceable. And so what I'm addressing is whether or not the principle of judicial review, that policies must be complied with absent good reason for not doing so.
But are the actions of individuals who happen not to have complied with the policy, whether or not the policy itself is enforceable, attributable to the government, or are they just actions of individuals?
Well, in the same way as if you have an official taking a decision in relation to an immigration matter, then one challenges the Secretary of State for the Home Department for any illegality on the part of that official.
But the person who's making a decision, in the example you've just given, is someone who's acting expressly under the authority of the Secretary of State, and the decision letter says so. My question is rather different. It concerns a person, let's say for the sake of argument, an official, who happens to have contravened a policy. And my question is the act of that official attributable to the government?
Well, we've seen from the terms of the policies themselves that they identify to whom they apply. We are dealing here with ministers.
Yes, but you're not dealing with my question.
I'm sorry, forgive me, but I'm not entirely clear what the question...
Right, well, I'm sorry, it's my fault for not making it clear. Are the acts of individuals who happen to have contravened one of these policies attributable to the government, or are they acts of individuals?
They're acts attributable to the government because they are done by individuals in their official capacity as officials to whom the policies are directed, in the same way as any government policy is directed to its officials to comply, and insofar as they don't, then the challenge is to the Secretary of State responsible for that department. That's the principles upon which judicial review works. Yes, I mean, all these policies are concerned with the acts of individuals in the conduct of government business. So what is being challenged here is a failure by an official acting in an official capacity, be that a minister, be that the Prime Minister, be that an official within the department, to comply with the terms of the policies that are imposed upon them by reason of their office.
Right. Okay.
So, can we turn to the justiciability of the ministerial code? And can I ask the court to look at the case of FDA and the Prime Minister, which is at tab 41.
I think.
I'm sorry.
Page 1489.
Thank you.
Your Lordships have it at tab 43. Oh yes, so do I. I'm sorry, I'm looking at the wrong folder. I apologise. If your Lordships can read quickly the head note, but not the holding. And then if the court can turn to paragraph 28, and here we can see the arguments advanced by Sir James in relation to the ministerial code. And the first sentence of paragraph 29. And then if we turn over through paragraph 31 to paragraphs 34 to 36, and if the court would read those paragraphs.
Sorry, 34 to 36.
34 to 36.
Right. And then 39 through to 43.
Yes.
So, in our case, with the security in government business policy, which the Ministerial Code speaks to, the policy itself is concerned to set standards for security purposes. And they're not standards that are being set for the purpose of the Prime Minister deciding whether to dismiss ministers who fail to comply. They are standards that are being set to protect against the myriad threats that can arise if security is breached in respect of highly sensitive, or what can be highly sensitive communications at the top level of government between ministers of state. And if those standards are breached, then one issue that the Prime Minister is rightly entitled to consider under the Ministerial Code is whether, by reason of that breach, the minister in question is fit to remain in office. And that's something we've obviously recently seen in relation to Suella Braverman. That is a political issue. That is an issue in respect of which the courts would have no jurisdiction. It is non-justiciable in the sense identified in the passages cited from the Shergill case. But, as FDA shows, this doesn't mean that there is necessarily a legal black hole in respect of the policy in its entirety. And because the Secretary of State is able to make, the Prime Minister is able to make decisions in respect of a breach that are political in nature, it doesn't in the least follow that a policy of this kind is not one that is susceptible to the principles of judicial review. And just as in the case of FDA, we submit that for precisely the same reasons here, this is a policy that is setting standards for government action in the exercise of what are undoubtedly public powers, and it is entirely appropriate that judicial review extends to constrain the manner in which that power is exercised. It's important to note that this is a separate policy from the Ministerial Code. FDA itself was actually concerned with the Ministerial Code, and that did not in and of itself mean that everything therein was not justiciable. So just to sum up, on all these policies, whatever the source of the power, they are powers which in their exercise and the manner in which they are exercised, they are subject to judicial review. So can I turn next to then look at the nature or the foundations of judicial review generally? This is not something I think that really can be avoided in this case, because we are looking at a decision by the Divisional Court in which it has looked at the way in which these principles have evolved historically, the sorts of cases, and have, by reason of what has happened as a matter of fact, constrained the application of those principles accordingly, without actually identifying any principled basis for doing so. So it is, in my submission, unavoidable that we've got to try and identify some principled underpinnings for what the court has been doing with judicial review in the last 40 years. The Divisional Court did look at some of this because at the time it was faced by an argument from Sir James that the dictum of Lord Diplock way back in the CCSU case should be regarded as the definitive statement on the nature and extent of modern public law. And the Divisional Court rejected that at paragraphs 104 to 1808 of its judgment. The argument is put at 103 of the judgment, or the argument put by Sir James at 103 is addressed and set out by the court. Sorry, put by Sir James is set out by the court at paragraph 103. And if the court can look at that and then read through to 108.
Yeah.
So we see the Divisional Court rejecting any argument that judicial review is somehow petrified as it stood at the time of the decision in the House of Lords in the CCSU case, and identifies statements of the court in which there is an articulation of the underlying basis of the principles of judicial review, which lay not in relation to the protection of private rights, but in the role of the court in preventing abuses and misuses of public power. Now, we endorse and we adopt that analysis. The case of AXA was cited. We refer also, my lords and my lady, to the case of Hunt, which is at tab 26 in the bundle, where your lordships note, my lady, at paragraph 16, page 953, the court again makes clear public law is not about private rights but about public wrongs. And consistent with this are numerous cases in which the courts have applied principles of judicial review to decisions that don't affect a particular individual but affect the public in general, and it's to this that my lady...
Which was the paragraph in Hunt?
It's paragraph 16, page 953.
It's all right. I just wanted that in my head. Thank you.
No, it isn't.
Yes, it is.
I'm sorry, it isn't that. Tab 26.
Public law is not about private rights, but about public wrongs.
Yes,
That is paragraph 16.
it is paragraph 16.
Mm-hmm.
So, as my lady stated this morning, consistent with this are numerous cases where the courts have applied principles of judicial review to decisions that do not affect a particular individual but affect the public in general. Can we turn to Walton and the Scottish ministers? This is a case which was concerned with standing, but in the course of addressing issues of standing necessarily had to address the nature of what can be challenged in judicial review proceedings. And that is at tab 23, and the relevant paragraph is 152, which is on page 774. I ask the court to read that paragraph.
Sorry, that's my fault. Which paragraph was it?
It's paragraph 152 on page 774.
Making the proposition that ospreys cannot bring their own proceedings.
Which of course they can't.
Which
But
they can't.
making the point that there are public interests. It's not just about the osprey's interest, but it's about the public interest in protecting ospreys and protecting wildlife and the environment. And that is something that is of significance for the public as a whole, And that's the clearest example is environmental matters, where the public as a whole is affected by a decision. And if we are looking at the narrow basis of CCSU, where we're looking at private interests that are being affected, then none of these cases will be challengeable. And we've moved well away from that. As we can see in the recent authority of Friends of the Earth, which is at tab 39, tab 39, the court can read the first page of the headnote.
Page.
That is page 1348.
Thank you.
Heathrow case.
The Heathrow case, exactly.
Yeah.
And then on the second page, in between A and B, there's a sentence starting halfway across the page. Hal appealed to the Supreme Court. And if the court then just looks at the basis of the challenge, it is quite plain that the reason that that decision was judicially reviewable, subject to administrative law principles, is not because the interests of Heathrow in having another runway were affected by the construction of the policy. It was because the interests of the public at large in the environmental implications were affected.
But this is a public-facing, published policy about airport strategy. What's this got to do with internal administrative policies?
I'm looking at the moment, my lady, at the question of what exercises of public power are subject to the principles of judicial review. And is it only the exercises of public power that are affect individuals, affect the private rights of individuals, affect the private interests of individuals, or is the exercise of public power subject to principles of judicial review because it affects the public interest in general as well?
Well, I'm not sure there's any dispute about that.
Well, it's if you'll allow me to take the steps in this argument, we will reach a point where it's relevant.
Okay.
I do promise.
All right.
So, can we then look at how CCSU is still relied upon by the respondents? And that's at paragraph 27 of their skeleton argument. They no longer make the very wide-scale submission that they did before the Divisional Court. They still rely upon it. And we can see they cite CCSU. In relation to these policies, they say, about 5 lines from the bottom, they do not concern the exercise of public power in an individual case. On the contrary, they constitute decisions insofar as they have consequences, which affect some person or body of persons other than the decision maker. And I'm not sure whether they meant they don't have those effects.
I'm so sorry, which paragraph
This
is
is paragraph 27.
27, thank you. My fault. Thank you.
And that is an important characterisation of the role of judicial review in CCSU and the Minister for the Civil Service. So they concern the exercise of public power they do not concern the exercise of the public power in an individual case. On the contrary, they constitute decisions insofar as they have consequences which affect some person or body of persons other than the decision maker. It's a typo. They do not affect persons. Yes, that's what I thought. It's precisely that they do. What they mean to say is they do not affect. So they're trying to again say in respect of these policies and looking at CCSU that judicial review has to can only concern itself with decisions that affect persons or a body of persons other than the decision maker. So that's the position that they're taking. Now, if that's what they are submitting, CCSU establishes, can I just make it clear that we agree with that? We agree that a challenge has to have effects, but those effects, when one is looking at what is said there in CCSU, it can include effects on a body of persons, and that body of persons can be the public at large. And that's the point, my lady, that my lady said it shouldn't be controversial, but I'm afraid it looks controversial given what they are saying there. And we submit these policies plainly have effects upon the public at large. They affect the public, which has a very, very significant interest in transparency and accountability in the exercise of government power. And these policies are all about security, transparency and accountability. So, can I turn next to another aspect of judicial review, which again is informative about its nature and scope, and what, therefore, what kinds of exercises of public power are susceptible to the principles of administrative law. And these are decisions relating to the determination of whether a decision by a non-government body is nonetheless susceptible to judicial review, so a non-public body. And here we see the courts taking a functional approach. And a good example of that is the case of Beer, which is at tab 14. And it starts at page 298.
Thank you.
And this case concerned a council that decided to hand over the running of its markets, or markets within the area that the council governed, to the stallholders, and it set up a company limited by guarantee to take over the markets. That's a D in the head note. The company's registered address was initially at the council's offices, and then it started operating the markets in January 2002. Could the court read E through to G on that head note page?
Yeah.
And then if the court turn to paragraph 16, and that's page 305, it seems to me that the law, this is in the judgment of Lord Justice Dyson, as he then was, it seems to me the law has now been developed to the point where, unless the source of power clearly provides the answer, the question whether the decision of a body is amenable to judicial review requires a careful consideration of the nature of the power and function that has been exercised to see whether the decision has a sufficient public element flavour or character to bring it within the purview of public law. It may be said, with some justification, that this criterion for amenability is very broad, not to say question-begging, but it provides the framework for the investigation that has to be conducted. There is a growing body of case law in which the question of amenability to judicial review has been considered. From these cases, it's possible to identify a number of features which point towards the presence or absence of the requisite public law element. I do not propose to examine many of these authorities. Leaving aside the market cases, it seems to me it's sufficient to refer to 2 recent decisions, and then, as he analyses those, we can go through, and if the court can resume in his judgment at paragraph 30, and if the court will read paragraph 30. Would have had that public element or flavour to which I have earlier referred. In this regard, the fact that the power is being exercised in order to control the right of access to a public market is a most important feature. Now, those policies, all the policies that we have looked at this morning, have a public element and character, excepting, for present purposes, that not all exercises of government power are necessarily public in this sense, are necessary of a governmental character. The policies in question undoubtedly are, because they are policies which have been formulated, the SGB, for the purposes of security and protecting the national interest, a quintessentially governmental function, and for the purposes of managing information in order to comply with statutory obligations that are aimed at securing transparency and accountability in the conduct of government in the public interest. So they are quintessentially the sorts of exercise of power that should be amenable to judicial review. That's point 1. And we will then look shortly at the law relating to the enforceability of public policies, and then we will move on to looking at...
Why aren't you judicially reviewing the policies?
Sorry, my lord?
Why are you not judicially reviewing the policies, then?
Because we don't have any objection to the policies. The policies are the policies, and we don't submit they're unlawful. I mean, it's possible to judicially review the legality of policies, that's the A case. But there's nothing in those policies that we submit as unlawful. Our ground of judicial review is a separately recognised ground in relation to policies. So, can I then very briefly take the court to another piece of academic literature, this time from Professor Mark Elliott, who seeks to identify, looking at modern case law, which has developed enormously since the CCSU days, and he's attempting to find the normative foundations and the purposes of judicial review as it is currently applied and has been developed by the courts. And I'm not pretending here, my lords and my lady, that we've reached a point of agreement, but in my submission, this is it precisely captures what it is that the courts are doing and what it is that the courts are saying they are doing. And that is at page 1710, and it's tab 50. So this, I would ask the court in its own time to read all those parts of this article that have been sidelined. He starts at 1 with looking at the justifications for and purposes of judicial review. And he then at A, on page 1709, outlines some of the inadequate justifications and purposes and takes them apart effectively and shows why they are not capable of explaining what it is that is actually going on when the courts engage in applying the principles of administrative law. He then looks at B on page 1710 for some suggested, or provides some suggested justifications and purposes. And in summary, if I can, just to summarise, he identifies there, towards the bottom of page 3, internal page 3, 1710, first judicial review exists in order to ensure compliance with the rule of law, and it is justified by the normative importance of ensuring that compliance. And he then goes on to analyse how judicial review performs that function. And one of the matters that he analyses is that judicial review, so in this guise, in a very narrow way in which it can be approached, is looking at the rule of law as the rules imposed by statute. And he then goes on to look at a second justification, a second aspect of those foundations, is that a special regime of legal control is necessitated by the uniqueness of the government's position. And this is towards the bottom of page 1711, internal page 4. And that uniqueness derives from a wide range of factors, prominent among which are the facts that government is unusually powerful and is uniquely devoid of any legitimate self-interest, meaning that it may properly only act in the public interest. Now, we've seen that that's not something that's necessarily accepted, but what remains true is that in many instances it does only act in the public interest, and when it does so in a uniquely powerful position and for that very unique purpose. And he then says that purpose overlaps with the first purpose. For instance, that's the upholding the rule of law. For instance, the unique powerfulness of government follows from the extent of its legal powers, control of which is required under the principle of legality, but nevertheless remains distinct from it. And in particular, the constitutional imperative of effective legal control of government is capable of justifying judicial review out with situations in which the government wields legal powers. And that's important because that brings us to the areas that we are looking at where government is wielding prerogative powers rather than statutory powers or third source powers. And even in those situations, it is acting in a unique situation insofar as it is acting in the public interest.
But I don't suppose you're asking us to erect a new boundary of public law on the basis of an academic text?
No, absolutely not.
I mean, there are a whole series of academic writers, I mean, Bell on an anatomy of administrative law, saying there is no unifying principle and it's a waste of time looking for one. I mean, that might be the other extreme.
Yes, but what if you will indulge me, my lord, to just look at the three principles and then look back to what the cases themselves are saying. And it is that marriage between what the cases are saying they are doing and what he is articulating here that, in my submission, gives this a particular value, this article. So if you will, my lords, just indulge me on the third aim of judicial review, which is to secure the public interest in good governance. The public is entitled to expect that government decisions will accord with standards of good administration, and judicial review exists in part to provide redress when those standards are not met. This third aspect of the foundations of the judicial review is important for two reasons, and he addresses those on the following page. It supplies the normative basis for the content of many of the controls enforced via judicial review. So he is there looking at what the courts are actually doing and providing a foundation that explains what it is on a normative basis that they're doing. And at the same time, recognising that judicial review is in part about upholding the public interest in good governance has important implications for the scope of judicial review. In particular, it liberates the scope of review from the legal and institutional fetters that it would obtain if the basis of judicial review failed to extend beyond the first two foundations, because that enables it then to...
I mean, what bothers me, Miss Kaufman, is that we're now at 3 o'clock on the first day, and you're not really tackling the 6 reasons given by the Divisional Court as to why...
I will come on to those, and I will be able to deal with them very quickly.
Right.
I promise. Once I've set the foundations, then a lot will flow.
The problem is, I mean,
this.
the foundations are familiar to us, perhaps more so to my colleagues than to me, but even to me, Ms. Kaufman. And obviously the idea that judicial review aims to secure the public interest in good governance, I don't imagine Sir James will be saying that that is not the case. But what he is saying, and what the Divisional Court said, is there have to be some limits, C re A, because if there are not limits, then there's a problem. And this is an area which is at the very least on the penumbra, and therefore you have to, because of all the points put to you by the bench this morning, and you need to persuade us that it pushes over into an obviously reviewable, being an obviously reviewable case when there is so much grey area here.
Well, in my submission, there isn't the grey area. There's the difficulty you've identified, my lord, with the policies, which in your view, those policies give rise to. That is quite separate from what the nature and scope of this particular public law principle is. Now, the reason I'm taking the court to these overarching principles about judicial review is that when one looks at this particular articulation...
Well, because you hope to take us there by small, I mean, it's an advocate's, if I may say so, a very well-trodden advocate's route. You say, well, you can agree with this, you can agree with this, you can agree with this, and therefore you must agree with this. True, maybe, let's assume in your favour that that's all very appropriately done. The problem is you can't dismiss the 6 reasons given by the Divisional Court and re A quite as simply as that, because they tackle the very duty in issue here.
Well, they don't. The 6 reasons do. A does not tackle the very duty.
No, A doesn't, but A is a premise.
And I will answer those observations of the Court of the Divisional Court, and I will submit they are not valid objections, and they are not based on principle.
I'm just giving you a warning that at 3 o'clock.
I'm grateful, and I'm
you
aware.
have to finish by 4:15, and for me at least, I need to be persuaded why they were wrong.
Well, I will now gallop along.
Yes, okay, don't gallop. But,
I think I've got no choice. I'm going to have to gallop. Can we turn now? Because I'm done now with the underlying principles. I'm done. We are now on the policy point. We are on compliance, this particular doctrine of public law, and its emanation and its nature. So Mandelier is the starting point. Paragraph 29, page 964. And I'm not going to take the court to much in Mandelier other than that. I just want the court to see quite clearly.
I'll say sorry, Ms. Kaufman. Which tab is that, please?
It's tab 27.
Thank you.
The legal effect on policy. Paragraph 29, page 964 at the bottom.
So what policy are we discussing? Is being discussed
We are
in this
discussing
case?
a policy in relation to, it's an immigration policy, and it does concern detention. I'm not going to contend any of these policies don't relate to the rights of an individual.
sorry, you're not going to...
Contend that there are any policy cases which have said there is a duty of compliance.
So this is all about the policy that applies when people are applying for leave to remain under the PBS, as far as I can tell from the head note. So it's not directly a policy about detention.
It is...
As far as the head note suggests.
I don't think it's a policy about detention at all.
I'm sorry, let me just come back to it. It's not about, I keep making this fundamental error, for which I apologise, and coming back to detention, but it's about an individual's rights and interests as affected by immigration policy. If we can go to 29 and just read paragraph 29 down to and including the citation from Lord Justice Laws in Nadaraja, which is the basis upon which they say the duty to comply arises.
Well, again, I mean, nobody doubts that in general terms. The question is whether it's applicable here.
I absolutely. So, but can we just take that as the starting point? That's the starting point. We see the marriage. We see those words identified. It is a requirement of good administration by which bodies ought to deal straightforwardly and consistently with the public. The first point being.
So if you've got a publicly published policy about how you're going to award points under the PBS, the person's got an expectation that you'll comply with the
point about Mandelier was it is unpublished, and that's why they had to dislodge, and this is exactly what they do in Mandelier, they dislodge the nature of this requirement of compliance from legitimate expectation, which is how it had been analysed for a number of years, and they make it clear this is not a species of legitimate expectation because it applies to published policies of which the individual has no knowledge. It is explicable on the basis that it is a requirement of good administration that you deal consistently and straightforwardly with the public. That is the bedrock of this duty, not legitimate expectation.
And treat like cases alike and all the rest.
Treat like cases alike, consistency, absence of arbitrariness, these are all principles of good administration that are virtues that this doctrine or this principle of judicial review pursues. So we've also got an older case. Can I take the court back to 1996 and to the case of Amasa, which I take the court to because it just shows how long ago this principle of good administration as the bedrock for this doctrine was recognised, and how in the ensuing years this got lost and it got swallowed up in the quagmire that is legitimate expectation. So if the court can look at tab 10 and the head note, and it is concerned with immigration, and it is concerned with an individual who was detained. If you can read the first paragraph.
Can you give the page, sorry?
I'm so sorry, it's 238.
Thank you.
And then, if your lordships return, my lady, to 243 and to paragraph A, in light of the foregoing, a modern approach to a departmental policy document, whether published or not, this is way back in 1996, whether published or not, ought to be as follows. The legal principle of consistency in exercise of public power creates a presumption that in the ordinary way the Secretary of State, through his officials, will follow his own policy. This presumption corresponds with the practical purpose of such an internal policy, which is precisely to secure consistency of approach, in this case, among officers administering the relevant immigration rules. If there is to be a departure, etc., etc. So that's exactly where principle comes from. It's a principle of general application. distinction, and it is embedded in the principles of good administration, such that right from the beginning, it doesn't matter whether the policy is published. And then, as I say, the law took a very wrong turn for a very long time. But in Mandelier, the court brought it back to something embedded in the principles of good administration. So the first question is, why should the principles of good administration, which here pursue the virtues of consistency, an absence of arbitrariness, and an equal treatment where it relates to individuals, why should they not apply to policies which are ones that affect the public interest in general? What is the principal basis for that distinction? And in our submission, there is none. For your lordships and my ladies' note, there is the case of ZLL and SS Housing Communities and Local Government, and that is at tab 46. I haven't got time to take the court to it. It doesn't take anything further. It just between 7.4 and 7.8 for your note, it sets out, it's Mr. Justice Fordham, and he sets out at paragraph 7 of his judgment, but of particular relevance to us are 7.4 to 7.8, some key basic legal points, he describes them, about policies, in the course of which he looks at 7.4 the duty of prescription. That is, those cases where the courts have said you actually need to have a policy. And what animates that duty is, again, precisely these same virtues: consistency and absence of arbitrariness and equal treatment. And those are the same virtues that animate a duty of compliance, which he also addresses and separates out from the duty of enforceability. That is the right of enforceability that an individual has where there has been the adoption of a policy. The two are treated separately, and in our submission that's significant, because the duty of compliance is not properly on a principal basis dependent upon a duty or a right to enforce on a part of an individual whose individual rights or individual interests are affected. Can I then turn very briefly to Good Law Project and the Secretary of State for Health and Social Care at tab 41. This is a case where, as the respondent rightly says, it was simply accepted by the Secretary of State in this case that the duty of compliance applies in general to all policies which constitute the exercise of public power, and therefore it applied to this particular policy. The ground, so there wasn't an individual right engaged in this case, and the object in this case of the policy that was or rather the policy which formed the bedrock of the challenge, the object of the policy was one of securing transparency and accountability in precisely the same way as these policies here are. Here it was in relation to procurement decisions, and the transparency policy that it was said had not been complied with in this case was one that related to matters that had to be published about contracts that had been awarded after they had been awarded. So that was the nature of the policy in place, had nothing to do with the rights of any individuals. Obviously it arose in the context of procurement, which affected individual rights, those rights of the contractors who were granted contracts. But this was being brought because of the requirements of transparency to which the policy gave rise. If the court can turn to paragraphs 22, first of all, where you can see briefly at 22 and 23 the policy itself and what had to be published.
Okay.
I'm so sorry, 1428. And then 28. So if the court can then move to paragraph 28, we can just see that it's not in dispute that Secretary of State failed to publish, this is at page 1429, he failed to publish redacted contracts in accordance with the transparency policy, and then at 125 to 130, the court addresses this failure. An example of how, unsurprisingly, the duty, insofar as it applies beyond the sphere of policies that affect individuals' rights, performs the important function of supporting good administration. It's no different, there is no difference whatsoever between the exercise of a public power in the context of an individual whose case is affected and the exercise of a public power for the benefit of society at large. It might be said that it's all the more important where one is dealing with policies that have significant effects on the public at large, such as policies to protect the environment, that there should be compliance, there should be consistency, and there should not be arbitrary decision making. So there is no principled basis whatsoever. Can I ask again for the court's note that the court looks in your own time at tab 49, which is again going back to Craig, and paragraph, it's 1704, the last para 22026 at 1705. Can I now turn then to an analysis of the Divisional Court's judgment? So, paragraphs 94 and 95 see the court as it's looking through the relevant case law. It says at 94, as will be apparent from that passage, and this is a passage taken from the judgment of the court in Mandalaya, origins of the recent development in the law relating to policies lies in cases which were concerned with detention of an individual. To some extent, this development was influenced by the incorporation of the European Convention on Human Rights into domestic law through the Human Rights Act, and this is because it is a requirement of the European Court of Human Rights that an interference with the Convention right, for example, to personal liberty in Article 5 must be prescribed by law, and it's well established in jurisprudence of the European Court of Human Rights that this does not always require law in the sense of legislation or other rules of law. It may sometimes be satisfied by the existence or publication of policies which govern the exercise of the discretionary power. And then they go on to say it must also be borne in mind in this context that the starting point is that any interference with the person's personal liberty will at common law be a tort typically for imprisonment. For that interference with liberty to be lawful, the defendant must be able to point to some lawful authority to detain, and frequently they'll be able to point to a discretionary power which has been conferred by legislation, but that authority in the legislation may itself be violated by a public law error, and so on. So if the court then looks at paragraph 97 to 102, we can see their analysis of what principles are derived from the authoritative. Firstly, policies are different from law and they don't create legal rights. Well, that's absolutely right, and we don't, in any sense, disagree with that. Secondly, and again we agree with this, they often serve useful functions in promoting good administration. Well, certainly do that, and compliance also serves useful functions in promoting good administration. And then they identify that there are situations in which a failure to comply without good reason will constitute a breach. And they then go on to look to some extent at what those situations are at 101. It may be that as the law develops it in its usual incremental way in this area, other contexts will arise in which a breach of policy without good reason will give rise to a breach of the law as well. It may be that although there is no interference with individual rights as such, a policy has been promulgated to cover the exercise of a discretionary power which may confer a benefit on a significant value of significant value, to an individual, for example, naturalisation. But such cases would still be ones in which there is an administrative decision by a public authority exercising public powers in relation to an individual case. So they're making quite clear there it has to be an incremental development and still be one which relates to the public case.
Well, you disagree with 100 and 101.
And we disagree with 100 and 101 and 102. In our judgment, public law has not reached the stage at which all administrative policies, and we've seen 103 to 108. So that's their judgment.
So is your proposition that all policies are amenable to judicial review?
No.
No.
Our submission is that all policies that constitute the exercise of public power in the sense that they are policies exercised in the public interest, that is strictly governmental, whether that be for a particular group within the wider public or the public in general, are subject on
Why
grounds
is that
of
not
good-
all policies?
I'm sorry?
Why is that not all policies?
Well, there are, as Lord Justice Carnwath was of the view that you can only exercise public power for the benefit of the public, but one can readily think of policies that
Can you
govern
think of one?
truly internal matters. Say, for example,
Can you think of one? Yeah.
for example, computers, and when computers fall to be renewed within a government department, or the use of paper, those sorts of policies.
Would you have a policy about the use of paper?
Well, you might well have a policy about.
I mean,
the use
I
of
do,
paper.
but I don't publish it.
You might well have a policy. You wouldn't publish it, but this principle applies whether you publish those policies or not.
Well, I mean, I use in the narrower sense, meaning make it available to other people. But I mean,
But
those are really trivial examples. Give me an example of a policy the like of which Lord Sales and Lord Burnett were talking about.
Those would be policies which constitute the exercise of public power. Absolutely. I don't resile from that. I absolutely take the position that almost all exercises of governmental power, by departments of state, within departments of state, are ones which will constitute the exercise of governmental power. Insofar as those are ones that seek to act in the public interest for the benefit of a section of the public, group of individuals, or the public as a whole, including environmental policies, including these policies which are there to secure transparency and accountability of government action, quintessentially a government policy these, then yes, they are subject to that principle. And they are subject to all the other principles that govern policy making by government, so that they are subject to challenge on grounds of irrationality. They are subject to challenge on grounds that they may be unlawful in directing decision makers to make unlawful decisions.
But your case isn't, except insofar as you challenge the done notice, I understand. Your case isn't about challenges to these policies, it's about allegations that the policies have been breached.
I absolutely accept that. What I'm trying the point I'm trying to make here, my lady, is that there are a number of principles of judicial review that have been constructed by the courts in relation to the legal effect of policies. And my submission is that each of those principles, and I don't think the defendant argues in relation to any of the others, each of those principles applies to all exercises of governmental power. And there is nothing peculiar about this particular principle which should, as a matter of principle, mean that it is confined to exercises that are for the benefit of an individual in conferring upon that individual or depriving that individual of a right, or perhaps incrementally a benefit. There is no principal basis so to confine those, this particular doctrine, insofar as it pursues the virtues of good administration by securing consistency, the very object of developing a policy in the first place. That's why governments develop policies, because they want consistent decision making. And all that this doctrine does is promote that and give it legal effect. Subject, of course, and this is fundamentally important, the doctrine recognises that there are exceptions and that you can depart for good reason. It is not a rigid doctrine, it is a flexible doctrine, which therefore, again, bolsters good administration by recognising consistency where consistency is required, unless there is good reason not to, and protects against arbitrariness. So that's the point. What is being done here, and it is a categorical error, is that the court is looking at the genesis. Where is it? What are the cases that have given rise to these challenges based upon the duty of compliance, and through which the courts have established the existence of these duties? And the fact is that a lot of them have been concerned with issues of fundamental rights in relation to the individual. And just because they have arisen in that context does not mean that as a matter of principle they fall to be confined in that context. And if one looks, for example, my lords and my lady, at the challenges brought in the 1990s in relation to the principle of legality. The principle of legality, which is now a bedrock of the common law and a bedrock of judicial review principles. A lot of that was developed in the context of prisoners' rights. And again, in relation to fundamental rights that prisoners enjoyed. But there was no sense in which it was so confined, the principle. It was brought in those areas because these individuals are subject to extremely coercive measures. And so lawyers become very creative in looking for solutions.
Can I ask one reason why there might have been not be cases in this area before, which is that obviously judicial review is a power the courts have to ensure legality of decision making, and that it respects constitutional boundaries on the separation of powers. And if the courts start messing around with every government policy which doesn't engage individual rights, we run the risk of actually undermining the rule of law because we're not respecting the proper boundaries.
In my submission, that is not a correct proposition. There is the principles of judicial review are legal principles of the common law. They're fashioned by the common law, and they are legal constraints upon the executive's action. And there is no infringement of the separation of powers, because what the court is doing here, the court is giving effect to those policies. It is not in any sense saying you cannot have those policies. It is saying to the government you can have those policies. What you just have to do in relation to those policies is have them applied, save where there is good reason. There's no sense in which there is an infringement upon the freedom of the executive to act. It's saying to the executive, you're entirely free to act. If you're going to make these policies which support good administration, then you apply them. And that is absolutely no different in the context of dealing with an individual whose rights are in issue, as it is in relation to the public at large. There is no distinction. You don't suddenly have a set of principles that only apply if rights are engaged in some way, unless you can say this is required because the nature of those rights, for example, arise under the Human Rights Act, and the Human Rights Act itself has a certain set of requirements, such as the Divisional Court observed in this case itself. But actually, that's not right. These principles did not derive and arise from Article 5. That's not what gave rise to these principles. We could see, if you go all the way back to Omarza, and you could see, if you look at the decisions themselves, those principles were not fashioned because of Article 5.
Can I put to you the reasons that the Divisional Court said? Because I know you say you're going to deal with them and they'll be very quick, but for me, it is an important part of your case. What they say is that these govern internal administration of government departments. Now, of course they do and they don't. They do, of course, govern internal administration, but they, you would say, are much more important for the protection of the public because of the security issues that affect everybody. But they then go on to say that where statutes provide for there to be guidance, it is obviously the statute that's important, and the guidance is given under the statute. And it's true here, isn't it, that the important policies that you rely upon are those issued by the National Archive, which you say were issued under Section 3.2. And as the Divisional Court said at 112, if the claimant's broad submissions were to be accepted, this would make no sense of those specific statutory provisions, because they say that you have to preserve the records subject to the guidance of the keeper, and these policies, you say, are all giving guidance either of the keeper or of the Secretary of State and to their departments, which is all for the purpose of making sure that these records are preserved in the future. I mean, that's the whole objective of all these documents. And what I don't understand is why that reason that the court gives is not a good reason. Why it shouldn't be subject to judicial review.
Could my lordship bring me back to the specific paragraph that you're referring to?
Well, I'm referring, I mean, unfortunately, I think the 6 reasons rather hang together, and you can't dissect
Can I come
them.
to each of them? Can I just
But
take the
the
court
point-
through those reasons?
It's 110 to 112, and then 113, which says there is accountability nonetheless.
Can I go through each?
Yeah, I think it would be helpful.
I was always planning to. I'm sorry.
No, I'm sure, but
it's
getting late. Yes.
So, the first paragraph, you have already recognised exactly what we say about that. It is wrong. These policies, 1110, are not policies which govern the internal administration of government departments and do not involve the exercise of public power. That is absolutely wrong.
Which bit is wrong?
They, of course, they do govern the internal administration of government in one sense, but they are profoundly about the exercise of of public power. They are the exercise of public power. If and insofar as they are Section 3.1 arrangements, that is a statute that has imposed upon the government a duty to make these arrangements, and the duty is to make those arrangements for the public benefit.
Move on, because that we've exchanged
Right.
discussion on that.
And in relation to FOIA, and in relation to all the other public purposes and public interests that those arrangements support. So we
Assume
submit
in your
that's-
favour there is an element of an exercise of public power. Assume
Right.
that's in your favour.
So that's the starting point. Next, the broad submissions advanced by the claimants do not sit easily with the fundamental principle of public law that guidance is precisely that and need not be slavishly followed. And there is a citation of a case called Edinburgh City Council. Now, Edinburgh City Council, firstly, let me make clear that they do sit comfortably with that principle, because the principle of public law that we say applies here
Is they cannot be followed except for good reason.
except for good reason. It is a flexible policy. So that is it is a bad point. It's also a point that is made in relation to a judgment where the legislation itself made it clear that, and this is at 1450C in page 268, tab 12. We can see this very quickly. 268, tab 12 for the case itself.
What are we looking at? Edinburgh.
We're looking at this case of Edinburgh Simpson and Nelson Corporation. So, page 1450C, in the judgment of Lord Hope, the development plan does not, even with the benefit of section 18A, have absolute authority. The planning authority is not obliged, in the words of Lord Guest, slavishly to adhere to it. It is at liberty to depart from the development plan if material considerations indicate otherwise. Now, if we then go to page 1458A, which is the section 18A that he just cited, 1458A in the judgment. That's the section 18A that he cited. It's right at the top. The provisions of section 18A and of the equivalent section 54A were status of development plan. Wherein making any determination under the Planning Act regard is to be had to the development plan, the determination shall be made in accordance with the plan unless material considerations indicate otherwise. So the statute says it in terms. So those are the two answers to that.
Yeah, but the third point is the one I really want you to get to.
The third point, then, let me take the third point. It's frequently the case that Parliament itself has set out to what extent the documents, such as the policy and code guidance, must be taken into account by a public authority. That is right. It frequently sets that out. So,
And it does here.
section 331 does not set out the extent. What it does is it requires arrangements are to be made. That's what it does.
And yeah, but section 3.2
But we're not just dealing with
says
section
every
3.
person shall perform, every person,
Yes.
ministers, everybody else, shall perform their duties under the guidance of the keeper.
Yes, and insofar as the guidance of the keeper touches on these matters, then the guidance of the keeper is what those individuals are obliged to comply with, absent good reason for departing. There's authority on guidance being required to be complied with in the same way. But we are concerned with section 3.1 guidance. It says nothing about how those arrangements are to be complied with. That is something that is determined by the principles of the common law. And if we just look at the examples, my lord, that are given by the Divisional Court itself, the Highway Code and PACE, they're two examples of where the court, the statute itself makes absolutely plain what the status of the guidance is in a way that simply doesn't apply here. So if we could just turn to the Road Traffic Act, for example.
Well, I don't think we need to waste time going to the Road Traffic Act. I mean, we're pretty clear that, of course, that's a completely different situation. But the point
So the answer to your points, then, my lord,
is that these are not, contrary to what I think you said earlier, these are not guidances given under 3.2, except for what, the one that
which is the Cabinet Office and the National Records, but that is a section 3.1 guidance as well. So the principle of
Well, it's a 3.1 arrangement.
I'm sorry?
It's a 3.1 arrangement.
Yes. So the policy is a 3.1 arrangement, and
Yeah.
the policy is something to which public law principles attach. That policies fall to be complied with, absent good reason. So my answer is, and my lord, if your lordship was of the view that my case was that these are all section 3.2 arrangements, that's not my case, and I apologise if that's the view.
No, I
you
understand
understood.
they're not all from the keeper, of course.
No. So
keep going. Number
and section and of course the SGB is not an arrangement made pursuant to statute at all. The security and government business. But also, insofar as these aren't arrangements made under section 3.1, they are just subject to public law principles. So
then the next
Then we
point
get
is
the
that
next.
there's still accountability.
Yes, so the answer to there being accountability is straightforward. The fact that there remain other accountability mechanisms does not provide a good reason for not taking a principled approach.
It's a very good reason for the administrative court not to entertain it, though, when you've got duplicative systems of public law to hold people to account, which is why it's so important at the beginning to specify what you're complaining about. I well understand at the start of the case you couldn't possibly have known all the policies and the breaches which the evidence disclosed, but that's why one looks then fairly at the amended statement of facts and grounds, and then says, fine, but let's leave that to the Information Commissioner. Fine, that can be dealt with in another way. There's no need for the administrative court, with its limited resources and time, to be dealing with these points.
I understand and I accept that. There are not, and it has not been alleged that there are alternative mechanisms by the other side by which... well,
that's partly because there isn't yet a schedule of breaches saying breach 1, X did Y, and that would be a breach of the code as well.
Well, in our skeleton argument, there was identified in the court below a very, very clear account of the breaches that it was said had taken place. And I understand from my learned juniors, I wasn't involved in the court below, but I understand that no issue was taken by the court in the court below of a failure to identify the relevant breaches by not schedulising them.
And the remedies that followed from those breaches.
Yes, nor was that point taken, no.
But I mean, that's not something that you can accuse the court of not taking the point. When you bring a judicial review claim, you have to say what relief you seek.
Well, I don't
we still haven't said. We still don't know.
The breaches were identified, and what was sought was declaratory relief in relation to those breaches.
I know, but just saying you want declaratory relief, unfortunately, begs a lot of questions.
Can I carry on with
yes,
with
this?
Yes,
can. I want to know about the fifth reason.
This fifth reason is true of almost all public law decisions. It is not a reason. There are alternative accountability mechanisms in relation to almost all public law decisions. In some instances, that will, as my Lord Justice Dingemans says, be a reason for refusing to entertain the case. But it's not a reason for not applying a principled basis or applying the doctrine on a principled basis. Can I just refer the court very quickly on that to Miller number 2, prorogation case, tab 37, paragraph 33.
Page.
Page 1301.
Thank you.
And if the court will read paragraph 33.
Yeah, well, pretty well-known case.
So, I'm sorry, my lord?
A pretty well-known case and a pretty well-known passage.
Yes, and an important passage.
Not
The other
practiced
accountability mechanisms do not mean that the court should step back from their own constitutional role or not apply and not take a principled approach, because there may be some difficult cases. Fifthly, the court says there would be a real risk that if public law were to regard such policies as being enforceable as a matter of law, public authorities would be deterred from adopting such policies.
And that's the one you just dealt with.
Well, I didn't deal with the deterrence point. No. In my submission, that is simply wholly unevidenced and utterly unrealistic. Government cannot work without policy. It simply cannot ensure that decisions are made in a rational, consistent and non-arbitrary way.
I don't understand why you accept the principle from Lord Burnett and Lord Sales that policies are not law.
They're not law. They can have effect in law.
Well, if they have legal effect and are enforceable in law, then they surely wouldn't have said that.
They are absolutely not law, and this principle does not turn what is a policy into a law. It is the very fact that you must be able to depart from the policy for good reason is a fundamental principle.
No, they say that in the context of if it were law, you would still be able to depart from good reason if it were a policy. Everybody understands what box you're trying to fit these policies into. You're trying to fit them into the box that says they are legally enforceable unless there are good reasons for not giving it legal effect, right? We understand that's the shorthand, but if you read the paragraphs in the Supreme Court's judgment, it's very difficult to see how all the arguments you've adopted to knock down the 6 reasons don't also knock down that passage.
Could my lord take me to the relevant passage?
Yes, go back in the judgment. We're in the judgment.
We're in A.
Yes.
We're in Miller now, not in A.
No, I'm sorry. I'm in the judgment of the court in this case.
Yes, but in what is the passage in the judgment of
Well,
A?
paragraph 90 of the Divisional Court sets out paragraphs 2 and 3 of the decision of Lord Burnett and Lord Sales, and we've read it several times. Policies can be you can read it. They're different from law. They don't create legal rights as such.
My lords, could we please go to A? It's tab 38. Tab 38.
Yeah.
Can we go to paragraphs 2 and 3 of A?
Yes, that's where I was.
So, reading this, we can see that policies may promote halfway down a number of objectives, in particular where a number of officials all have to exercise the same discretionary power and the stream of individual cases to come before them. A policy may provide them with guidance so that they apply the powers in similar ways and the risk of arbitrary and capricious differences in outcome is reduced if placed in the public domain. Policies can help individuals, etc., etc. And then it says, in the next paragraph, they are different from law, and included in that paragraph between C and D, having stated they're different from law, it's also made clear that if the policy is not made public and an affected individual is unaware of its relevance to his case, and in that sense had no actual expectation arising from it, the authority may still be required to comply with it unless able to justify departing from it. That is part of the principles that govern the making of policies. They are not law, but there are legal principles which give them some legal effect. That is a fundamental distinction. So the principle of public law here is you must comply with your policy unless there is good reason to depart from it. That is a principle that does not convert a policy into a rule of law, because for the very reason that the nature of the principle itself permits departure, because the policy arises out of the exercise of a discretionary power, and you cannot fetter the exercise of discretionary power by making rigid rules. So it's absolutely the case that this is not a legal rule, and so the arguments put forward by the Secretary of State that there is in some sense an interference with parliamentary supremacy by the creation of rules is wrong. It is not a rule. It is a principle of administrative law aimed at securing consistency, transparency, equality of treatment, and preventing arbitrary decision-making. So coming back to that fifth objection, we submit that there is, as I say, no evidence whatsoever that it would create any disincentive for the creation of policies, precisely because they are, as the Supreme Court itself observed, of real utility to effective governance. And to think that a policy which is aimed at giving effect to those very reasons why you adopt policies, and which allows departure for good reason, is going to somehow be a disincentive for government, in our submission is impossible to comprehend. It is all aimed at facilitating good administration. And I come back to the point, if these policies, framed in their terms, are not serving the government's purposes, then the answer is don't do damage to a consistent application and a principled approach in administrative law, change the policies. And governments are entirely free to do that. So, my lords, I think then the last point is one that we don't disagree with. The last point, the sixth point, which is that these policies must be clear and unambiguous in their terms. Well, in our submission, these policies are all exactly that. So we don't, in any sense, resolve from that, and for those reasons, we submit that the Divisional Court's 6 reasons simply do not bear scrutiny.
Can I ask about the clear and consistency between the policies? Because there is a suggestion, you may say it's wrong, that some of the policies contemplate using private emails and some don't, like the SVG doesn't and the DHSC does, because it talks about putting your private emails onto a repository. What do you say we should do in those circumstances?
So in my submission...
Say, grant a declaration that you complied with this policy but not that one, or that the policies are inconsistent and you shouldn't have inconsistent policies, or what?
So my submission is that, say for the done policy, which we'll come on to, there isn't that inconsistency. The 2013 policy that we looked at, the last policy we looked at, which said you may use emails, in my submission, the proper construction of that is, and that's obviously for the court, is that all it's doing is being descriptive of what might happen.
It's terrible drafting, if that's what it means.
I'm sorry?
It's terrible drafting, if that's what it means.
Yeah, but the court has to then construe
what confusion.
But isn't that one of the problems, that these are policies, not statutes?
But that's the problem that the court has to contend with whenever it's dealing with policies, and there's no dispute between the parties that it's for the court to construe policies. That is the job of the court. Now, we have a body of policies which, in my submission, make it quite clear, and also the wording there, which says that the security policies, that this is all subject to security policies, and the sentence that immediately follows that use of the word may, makes it quite clear that it's just descriptive.
Well, I agree, it makes it thoroughly ambiguous. But what Ms. Kaufman, I've been trying really to persuade you all day, is to grapple with the enormity of the case you're advancing. If you had delineated your case, as my lord has been suggesting all day, and said what it was that was broken and by whom, then it would have been possible for the court to evaluate whether that was the kind of government statement of policy which could be given legal effect. But the blanket approach, which says we should treat as legally enforceable 7 or 8 or 9 disparate documents of 10 or 12 or 15 pages with things that are contradictory within them, makes it very difficult, and also highlights what you've been resisting all day, which is the court's inherent feeling that if we regard all this as legally enforceable, we're going to have zillions of I said zillions of cases, and you said, well, we won't know about it, so we won't. But we're going to have to do a lot of this, which we didn't think we had to, and there's never been a case like this before. And in the last few minutes this afternoon, it would help me if you could say, no, you really should grasp this nettle, you, the court, because if you don't, there will be very severe consequences. I know you say that for the rule of law, for accountability, for transparency. And the other thing that troubles me is that there seems to be a sort of sliding between the PRA, which is what I thought this morning this case was about, and some much more general government duty to give policies about the retention of documents. Now, and that's several questions rolled into one, but I don't want to talk more than is necessary. That's what I'm worried about, is that really this is a giant leap forward in public law. And
Can I start with the last point first?
Yes.
We don't contend for any duty on the part of the government that isn't, as it were, contained in the PRA, for example, to make these policies. We are here dealing with policies that have been made, and therefore the question is, what are the implications in public law for the fact that these policies have been made? The PRA we have focused on because it seems to us it is a clear exercise of the Section 3.1 arrangement that the policies are, at least to some extent, made pursuant to that Section 3.1 duty. And the significance of their being promulgated pursuant to that Section 3.1 duty is simply that it demonstrates that these are exercises of public power, and it meets the point of the very first point of paragraph 110 of the Divisional Court's judgment, that these are not the exercise of public power. So that's the significance of them. But, as I've made clear, if they're not Section 3.1 arrangements, they're nonetheless lawful exercises of some other power, a third source power. And we don't dispute that. So that's the last point. As to whether this is some enormous leap, in my submission, it isn't an enormous leap. The courts have been, until the Divisional Court, and in fact, in my submission, the Secretary of State, no doubt government departments, have been operating on the basis that this principle of compliance, let's call it that, the principle of compliance, is one of general applications to government policies where they involve the exercise of public power. And there's no... It absolutely is not the sort of step or legal constraint which the courts impose for the purposes of securing good administration that is liable to do damage to governance. Quite the contrary. Its very purpose is to bolster good administration. And its very purpose is to support the very reason why policies are implemented in the first place. So it's very difficult to see and understand why great damage should be done to governmental action by this policy being applied on a principal basis. So that's one answer to what your Lordship says. As to what damage might be done if this doesn't happen, then in our submission, serious damage can potentially be done, because governments will be free to implement policies that are for the benefit of the public in general, without the safeguard of a guarantee that those policies will then be applied consistently in consistent cases, without the benefit that the application of those policies will give to ensuring that arbitrary decision-making does not take place.
You see that, I mean, just to interrupt you there, that was really the point I was driving at this morning, right at the beginning, when I said this is a developing area where technology changes daily, people's usage of technology changes all the time, and so the hope for a lovely plain vanilla policy which can be implemented consistently across government forever and a day, at that stage in the development of technological usage, is unlikely to be realized. And that's why I said to you, and it's similar to the point about the 9 or 10 policies, all of 10 or 20 pages, this looks to me, with the best will in the world, like the government struggling to get its policies right in this very fast-moving technological era, and therefore to be preeminently something, and I'm speaking only for myself here, that might be said to be unsuitable for a legally enforceable policy at this stage, but at some stage it might be very suitable for a legally enforceable. Or it might be possible to say, which is why I urged you to say this is the one we put our money on, that this was the really central, the fons, I'm not going to use Latin, the fountain of the fountain of the power and the policy. This is the really important one. But because you've taken what I'm going to accuse you won't like it, a scattergun approach, and tried to put everything into the pot, it makes me feel cautious about whether I can go with you and take that leap. I said this morning, as you heard, that I am, because of my duties, my own duties under this Act, I am entirely committed to transparency, to the publicisation of public records being available to the public and properly selected, and the duties being properly complied with. All that absolutely is very, very important. I'm part of its instrumentation. But you can't just come along and say, look, this is all terrible, whilst it may be, without being much more specific about what, if I can put it this way, about what is terrible and what the breaches are, so that the court is given something to bite on. And now I will shut up.
Can I attempt to answer some of that?
Well, can I just sort of maybe short circuit it? Page 277 of the core bundle is the details of the decision to be judicially reviewed. There's a reference there to breaches of statutory duty, defendants' own policies, as particularised in the SFG. One then goes to the statement of facts and grounds, paragraph 83A. There's a list of things that you say are breaches. Is that your pleaded case?
Yes, and my lords, can I attempt to answer some of the concerns that you've just expressed? So first, as to the scattergun approach, we are dealing with policies that affect different government departments. We were dealing with four respondents and all their own policies. So that's unavoidable because they all have different policies. So we've got to look at what those policies are. The real issue for the court is, as the court, Divisional Court itself said, is before you can treat any policy as having any legal effect, it has to be of a particular kind. So it's the kind of policy, paragraph 115, page 107 of the core bundle, it's the kind of policy the Supreme Court had in mind in Friends of the Earth, a formal written statement of established policy. Now that's the test, and it is. These policies they are formal statements. So insofar as they are clear in terms of what they require and unambiguous in terms of what they require, then the fact that there are many of them, because there are a number of different government departments who are issuing policies, I'm afraid does not affect the question of whether they are legally enforceable. Turning to your second point, your concern that this is a fast developing field where we are dealing with constantly evolving methods of communication. Firstly, I would highlight that many of these policies we saw as we went through constitute the recently considered view of the government in the face of, in particular, it having become apparent that there is use by government officials, ministers and the Prime Minister, of such technology and communications mechanisms privately. And these policies are the considered view of the government that they should not be used, or the material should be recorded. So, however much your Lordship has a concern that these things are continuing to evolve, and I understand precisely why your Lordship has that, these are nonetheless the policies currently in place that the government itself has decided are and should be applicable, and that it wishes to be consistently applied.
You see, when you say these, what's these? I mean, the one for the Department of Health and Social Protection is not bad. Some of them may be, and some of them mayn't. That's the point.
So there is a security and government business policy that makes it absolutely clear you should not use private devices. There are then other policies that also make that clear, or deal with securing information which is generated through prohibited use, securing its transfer onto government repositories. There are those two examples, and yes, it's necessary to go from one policy to another to an extent. But the answer, my lord, to the point that we are in a fast-changing, fast-moving world in terms of the development of these technologies is in the principle that policies fall to be applied absent good reason not to. And insofar as there are good reasons because of this evolving environment, then that means there is no breach of the duty. It is a flexible duty that recognises the needs of governance and the discretionary nature of the powers that are being exercised. So the kinds of concerns that your Lordship is expressing in our submission simply do not arise. My Lords, we've got 5 minutes and I haven't started on standing.
Oh, right, you haven't started on...
I haven't started on standing, I haven't started on done.
Standing is not your... It's a reply point, isn't it? It's a respondent's
I'll happily
notice.
deal with standing.
Well, it's a respondent's notice.
Lovely.
But you do need to deal with the
Done.
memo, and if you deal with that tonight, I'd like to give you, if Sir James will not object, and if he does, we'll think about it. But I'd like to give you 15 minutes in the morning to think about what we've all put to you, and just to, if I can put it this way, put your best foot forward in an encapsulated way in your own words, with an undertaking from the court not to say a thing. Because I'd like to give you that opportunity, because overnight sometimes things settle down in your mind.
I'm great.
And I think we've got the luxury of time, haven't we? Yes. Okay.
Can I deal then? It's actually Bell and Dunn. So Bell, I can deal with very, very briefly. Professor Bell is obviously not a government official, not a minister, but he was in frequent communication with the government during the COVID crisis, in particular in respect of trying to secure contracts with individuals who might make lateral flow antibody tests as opposed to the antigen tests. So this is what was at a time when it was thought...
I remember them.
Yes. I mean, we could all be, once we've had it, immune for good. So let's get lots of these. So there were lots of communications. We addressed this, I think, in our skeleton, so I don't need to take you to it, but would your Lordships like for your note just to see where it's all dealt with? So, for your note, Mr. Vinyl, in the supplementary bundle, page 56, paras 80 to 86. And then Ms. Abbott in her...
Can you give me that again?
Sorry?
Can you give me that reference?
Oh, sorry. Yes. Supplementary bundle, page 56, paragraphs 80 to 86. And then Ms. Abbott in her third witness statement, paragraphs 35 to 39 at page 161 of the supplementary bundle. And included in that is part of the judgment of Mr. Justice Fraser at page 162. And I'd ask the court to note how he describes Professor Bell's important role. Now, we know that there were absolutely no arrangements to capture any of his discussions that were not with officials. So he had this role in relation to contractors, and so there were matters that he discussed that were not captured by government officials. And there are simply no arrangements in place to capture that material. Now, our argument is entirely premised, as the respondents have correctly noted, upon us being correct about the nature of the construction of Section 3.1. So if Section 3.1 includes, by necessary implication, a duty to make arrangements for the capture and preservation of such documents until the selection for permanent preservation is made, then in our submission there is a failure to have in place arrangements which are required as a matter of statute under Section 3.1. That's the simple point. That's the Bell point. The Dunn note, now that is in the core bundle, page 348, right at the end of the core bundle. Can I ask the court to read paragraphs 2, 4, 5, 8 and 9 11.
Can I ask a question, please? What is the guidance that's referred to in the first line of paragraph 2?
Paragraph 2.
I mean, maybe you don't know.
I think that's all the guidance, I suspect, that applies to ministers. I don't know.
All right.
But that is a summary, an attempted summary of whatever guidance is considered to be applicable in relation to the use of private email.
Right.
This is just sent to ministers at the Health and Social Care Department.
Yes, it is. Can I say, in respect of what is stated there at A, that is it probably not quite strong enough to describe what the totality of that guidance is and its legal effect. But it does effectively say you should not use private email for substantive discussions, save where there are exceptional circumstances.
So that bit's not unlawful.
So that is an accurate description of what the totality of the guidance is.
Which bit is unlawful?
And then we get she explains what she did, she undertook to consider it, and then we come down to paragraph 8, use of private devices and email accounts. And she then says, this is the new guidance at paragraph 8, official departmental email systems and applications should always be used for communicating any classified information. However, existing Cabinet Office owned cross-government guidance states that, so she's referring to what is already stated, other forms of electronic communication may be used in the course of conducting government business. She then leaves out entirely, and it's all subject to the security or whatever security policy.
She construes it in the way that is you disagree with.
Exactly. And so our submission is a straightforward one. You've got a piece of inconsistent guidance which is not purporting to be new guidance, it's purporting to summarise existing guidance, and insofar as it is taken to permit that which is not permitted under the guidance, then it is irrational.
Well,
or it should be made clear that it doesn't mean anything different to what the actual guidance it is supposedly summarising is saying.
But am I right in thinking that the underlined bit at the end of paragraph 8 is a hyperlink? Because if it's a hyperlink, the person who's reading this can just go straight and check what it says for themselves.
Yeah, but
So what's wrong with that?
it's this. Use of text messages. You can see how it's construed at paragraph 13. Use of text messages, WhatsApp and other similar messaging systems on private devices at 13. As with email, the use of private accounts devices to send and receive WhatsApp or text messages is not prohibited. Well, it is. However, the originator or recipient needs to determine whether the information contained therein constitutes substantive discussions or decisions generated in the course of conducting business, and if so, take steps to ensure the relevant information is accessible. So it actually makes quite clear that that guidance, to which it says it is simply, which it says it's simply citing, is actually to the effect that it is permissive and allows the use of private devices.
Or it recognises that it might happen and tells you what to do if it does happen.
No, because it says in terms it's not prohibited.
No, I'm referring to what the effect of the guidance which is summarised.
Yes, but the understanding of the effects of that guidance is also made clear in this document at paragraph 13 to the effect that, as with email, the use of all these other devices is not prohibited. Now, if our submissions are right, it is prohibited, subject to there being exceptions, but the starting point is it's prohibited.
All right, so it depends on what.
So that's the done point. And that brings us to just past 4:15.
Well, it's been a big day, Ms. Kaufman. Thank you very much. We'll adjourn and let you have your 15 minutes to encapsulate your submissions in the morning. Yeah. Okay. 10:30.